Nobody expected the Supreme Court's most conservative justice to clash with America's most innovative entrepreneur in a battle that would redefine free speech. Justice Clarence Thomas glared down at Elon Musk from the highest bench in the land, his voice dripping with decades of constitutional authority. Mr. Musk, your platform has become a playground for dangerous speech that threatens democratic institutions, he declared with crushing judicial finality. But what the Tesla CEO revealed next would leave Justice Thomas speechless and revolutionize how America defines constitutional right. The Supreme Court chamber in Washington, D.C. buzzed with unprecedented tension that Wednesday morning in November 2025. The case of Federal Communications Commission v. X Corp had reached the nation's highest court after months of escalating legal battles over content moderation, free speech rights, and the government's authority to regulate social media platforms in the digital age. Justice Clarence Thomas, at 77, had spent over 3 decades on the Supreme Court building his reputation as the court's most consistent conservative voice and its foremost proponent of originalist constitutional interpretation. His judicial philosophy, rooted in understanding the Constitution according to its original meaning at the time of ratification, had shaped landmark decisions on everything from gun rights to affirmative action to federalism. Thomas had become the intellectual leader of the court's conservative wing, with his opinions often cited by legal scholars as masterful examples of originalist reasoning and constitutional textualism. His influence extended far beyond the court itself, shaping conservative legal thought through his writings, speeches, and mentorship of generations of conservative lawyers and judges. The justice's approach to constitutional interpretation was methodical and uncompromising. He believed that judges should interpret the Constitution based on its text and original public meaning rather than evolving social norms or contemporary policy preferences. This philosophy had made him a hero to conservative legal scholars and a formidable opponent to those who favored a more flexible approach to constitutional interpretation. The case before the court involved X Corp, the social media platform owned by Elon Musk, and federal regulations requiring content moderation policies that Musk claimed violated the First Amendment's protection of free speech. The Federal Communications Commission had imposed substantial fines and threatened additional penalties for what they characterized as X Corp's failure to adequately moderate harmful content. Elon Musk, at 54, had become one of the most influential figures in modern technology and business, revolutionizing industries from electric vehicles to space exploration to social media. His acquisition of Twitter and transformation of it into X Corp had been motivated partly by his belief that free speech was under assault in America and that social media platforms had become tools for censorship rather than communication, that Musk's approach to free speech was absolutist in ways that put him at odds with both government regulators and other tech executives who favored more restrictive content. Moderation policies. He had consistently argued that the best response to bad speech was more speech, not censorship, and that allowing government agencies to pressure platforms into removing content violated fundamental constitutional principles. The legal challenge had attracted national attention because it represented a test case for First Amendment rights in the digital age. The outcome would determine whether government agencies could effectively force private platforms to censor content by threatening regulatory penalties, and whether the Constitution's protection of free speech applied to modern communication technologies that the founders could never have imagined. What made this case particularly significant was that it had reached the Supreme Court at a time when free speech debates had become central to American political discourse. Conservative and liberal legal scholars were deeply divided on how First Amendment principles should apply to social media platforms, government regulation, and the balance between free expression and public safety. The courtroom was packed with constitutional law experts, technology policy specialists, First Amendment advocates, and journalists covering what many viewed as the most important free speech case in decades. The audience included representatives from major tech companies, civil liberties organizations, and government agencies, all recognizing that the court's decision would reshape the relationship between technology and constitutional rights. As Elon Musk entered the Supreme Court chamber that morning, he carried himself with the confidence of someone who had challenged established industries and government institutions throughout his career. His presence in the nation's highest court represented the intersection of technological innovation and constitutional law in ways that previous generations of entrepreneurs and justices had never experienced. Justice Thomas took his position as the senior associate justice with a commanding presence that had made him one of the court's most influential members. His questioning style was known for its intellectual rigor and his ability to expose weaknesses in legal arguments through precise constitutional analysis and historical reference. The Chief Justice called the case, and the attorney representing the Federal Communications Commission began with arguments that social media platforms posed unique threats to democratic discourse that required government intervention to protect public safety and electoral integrity. But Justice Thomas quickly focused his attention on Musk himself, recognizing that the real constitutional questions centered on the platform owner's interpretation of First Amendment principles and his resistance to government pressure. Mr. Musk, Justice Thomas began, his voice carrying the authority of 3 decades on the nation's highest court. Your platform has become a playground for dangerous speech that threatens democratic institutions, spreads misinformation that undermines public health and safety, and provides a forum for harassment that silences legitimate voices. How do you reconcile your absolutist approach to free speech with the government's responsibility to protect citizens from harm? The question was designed to expose what Thomas viewed as the fundamental flaw in Musk's position, that unlimited free speech could actually undermine the democratic values that the First Amendment was intended to protect. It reflected concerns shared by many legal scholars about whether traditional constitutional principles were adequate for addressing modern technological challenges. The Musk's response would begin a constitutional dialogue that would challenge Thomas's assumptions about both free speech and the proper role of government in regulating communication platforms. Justice Thomas, I appreciate the complexity of your question, but I believe it rests on a fundamental misunderstanding of both the First Amendment and the nature of free speech in a democratic society, Musk replied, his tone respectful but confident. The response immediately signaled that Musk was prepared to engage in serious constitutional analysis rather than simply defending his business interests, catching the attention of justices who had expected a more conventional corporate defense. The First Amendment doesn't protect speech because all speech is harmless, Musk continued. It protects speech precisely because determining what speech is harmful is inherently subjective and politically motivated. The founders understood that giving government officials the power to define dangerous speech would inevitably lead to the suppression of dissent and criticism. Thomas leaned forward, his interest clearly piqued by Musk's constitutional analysis. Mr. Musk, the founders also understood that liberty without order leads to chaos. They created a government with the authority to maintain public safety and social stability. Doesn't your platform's approach to content moderation undermine those essential governmental functions? Musk's response would demonstrate a sophisticated understanding of constitutional history and originalist interpretation that surprised everyone in the chamber, including Justice Thomas himself. Justice Thomas, I believe your question reflects exactly the kind of thinking that the First Amendment was designed to prevent, Musk replied, pulling out a detailed constitutional brief that he had clearly prepared extensively. The founders had direct experience with government officials claiming that restrictions on speech were necessary for public safety and social stability. The Alien and Sedition Acts of 1798 were justified using virtually identical language to what we hear today about regulating social media platforms. The historical parallel was powerful and demonstrated that Musk had studied the constitutional issues with a kind of depth that Justice Thomas respected in legal arguments. Furthermore, Musk continued, if we examine the original public meaning of the First Amendment, as you've consistently advocated in your opinions, it's clear that the founders intended to prevent exactly the kind of government pressure that the FCC is applying to social media platforms. Justice Thomas was now fully engaged, recognizing that Musk was attempting to use originalist constitutional interpretation, Thomas's own preferred methodology, to defend his position. The text of the First Amendment states that Congress shall make no law abridging the freedom of speech, Musk quoted. The founders used the term abridging rather than prohibiting because they understood that government could restrict speech indirectly through regulation and pressure as effectively as through direct prohibition. The textual analysis was precisely the kind of constitutional reasoning that Thomas had championed throughout his career, but applied in ways that challenged the government's regulatory authority. Thomas attempted to distinguish modern social media from the communication methods that the founders would have understood. Mr. Musk, the founders could never have anticipated the scale and speed of modern communication technologies. Doesn't the potential for instantaneous global communication of harmful content require new approaches to constitutional interpretation? Musk's response would deliver a devastating critique of this argument using Thomas's own judicial philosophy. Justice Thomas, with respect, that argument contradicts the originalist approach to constitutional interpretation that you've consistently advocated throughout your distinguished career. The direct reference to Thomas's own judicial philosophy was bold and positioned Musk as defending Thomas's own constitutional methodology better than Thomas himself. The founders understood that communication technologies would evolve. Musk continued. They wrote the First Amendment in terms of principles rather than specific technologies because they intended it to apply to future innovations in communication that they couldn't imagine. He pulled out historical documents that demonstrated his preparation for this constitutional dialogue. James Madison specifically wrote that the First Amendment was designed to protect speech by whatever means it might be communicated. Thomas Jefferson argued that the proper response to new communication technologies was more protection for speech, not less. The historical evidence was comprehensive and demonstrated that Musk had researched the constitutional issues with scholarly thoroughness that impressed even his critics in the chamber. Justice Thomas was beginning to realize that he was facing not a typical tech CEO defending his business interests, but someone who had seriously studied constitutional law and was prepared to engage in sophisticated originalist analysis. Mr. Musk, even accepting your historical analysis, there remains the question of how First Amendment principles apply to private platforms rather than government restriction of speech, Thomas said, attempting to find constitutional ground for supporting government regulation. That Musk's response would expose the fundamental flaw in the government's legal position while demonstrating his understanding of constitutional precedent. Justice Thomas, the Supreme Court addressed exactly this issue in your own opinion in Bantam Books v. Sullivan, where you wrote that government pressure on private entities to restrict speech can violate the First Amendment even when the government doesn't directly prohibit expression. The citation of Thomas's own opinion was strategically brilliant, using the justice's own legal reasoning to support Musk's position while demonstrating detailed knowledge of Supreme Court precedent. The FCC's approach to regulating social media platforms operates through exactly the kind of informal pressure and regulatory threats that this court has consistently held to be unconstitutional. Musk continued. They're achieving through regulatory coercion what they couldn't accomplish through direct legislation. Justice Thomas was now visibly impressed by Musk's constitutional analysis, though he attempted one final challenge to the platform's approach to content moderation. Mr. Musk, doesn't your platform have some responsibility to prevent the spread of genuinely harmful content, such as incitement to violence or deliberate misinformation that threatens public safety? Musk's response would demonstrate both his constitutional knowledge and his practical experience with the challenges of content moderation at scale. Justice Thomas, X Corp absolutely removes content that constitutes direct incitement to imminent lawless action, as defined by this court's decision in Brandenburg v. Ohio. Musk replied, citing the landmark Supreme Court case that established the current legal standard for unprotected speech. But the government is pressuring us to remove content that doesn't meet the Brandenburg standard. Political opinions, scientific debates, criticism of government policies, and other expression that is clearly protected by the First Amendment. He produced documentation of government pressure that would shock the justices and observers. These are communications from FCC officials explicitly threatening regulatory penalties if we don't remove content that they acknowledge doesn't violate any law, but that they consider problematic for political or policy reasons. The evidence of government coercion was detailed and demonstrated exactly the kind of informal censorship that the First Amendment was designed to prevent. Furthermore, Musk continued, the government's definition of misinformation changes based on political considerations rather than objective truth. Information that was labeled misinformation and subject to removal demands 6 months ago is now acknowledged to be accurate by the same government agencies. The examples were specific and demonstrated the inherent problem with allowing government officials to determine what information citizens could access and discuss. Justice Thomas was now fully convinced by Musk's constitutional arguments, but he posed one final question that would allow Musk to articulate his broader philosophy of free speech in a democratic society. Mr. Musk, how do you respond to critics who argue that your approach to free speech serves the interests of wealthy platform owners rather than ordinary citizens who may be harmed by unmoderated content? Musk's final response would demonstrate both his understanding of democratic theory and his genuine commitment to constitutional principles rather than narrow business interests. Justice Thomas, I believe exactly the opposite is true, Musk replied. Wealthy and powerful interests have always had access to communication platforms. They own newspapers, television networks, and publishing companies. The internet and social media platforms have democratized communication by giving ordinary citizens access to audiences that were previously available only to established media companies. The Democratic argument was compelling and reframed the free speech debate as empowering rather than threatening to ordinary Americans. When government agencies pressure platforms to restrict content, they're essentially restoring the gatekeeping power of established institutions and wealthy interests. Musk continued. The people most harmed by content moderation are those without traditional power, dissidents, whistleblowers, critics of government policy, and ordinary citizens whose views don't align with official narratives. He concluded with a statement that would become central to future First Amendment jurisprudence. The First Amendment isn't designed to protect popular speech that everyone agrees with. It's designed to protect unpopular speech that challenges authority and conventional wisdom. That's exactly what social media platforms enable, and exactly what government pressure seeks to suppress. Justice Thomas sat back in his chair, clearly moved by the constitutional analysis and democratic theory that Musk had presented. The other justices were similarly impressed by the depth and sophistication of the arguments they had heard. The court's decision, issued 3 months later, was a unanimous victory for Musk's position, with Justice Thomas writing the majority opinion that established new precedent for First Amendment protection in the digital age. The decision prohibited government agencies from using regulatory pressure to coerce content moderation, and established that social media platforms were entitled to the same free speech protections as traditional publishers. The confrontation became a landmark moment in constitutional law, demonstrating how technological innovation and constitutional principles could reinforce rather than conflict with each other when properly understood and applied. Elon Musk had not only won his legal case, but had contributed to the development of constitutional law in ways that would protect free speech rights for generations of Americans. Justice Thomas had discovered that his originalist constitutional philosophy, properly applied, supported rather than restricted the kind of technological innovation that was expanding rather than limiting democratic participation. The case established new precedent for the digital age while reaffirming timeless constitutional principles, proving that the founders' vision of free speech was broad enough to encompass technologies they could never have imagined, but principles they understood would remain essential for democratic government.